Namaskar everyone. In previous lecture, I discussed the salient features of the Indian Constitution. In today's lecture, I will do the same chapter or the same topic. In previous lecture, we discussed the 5 salient features of the Indian Constitution. Now, sixth feature is the fundamental rights. इट इज मोस्ट इम्पोर्टेंट फीचर ऑफ द इंडियन कॉन्स्टिट्यूशन. एक बहुत ही महत्वपूर्ण विशेषता है भारतीय संविधान की. द फंडामेंटल राइट्स आर मेंशन इन द पार्ट 3 ऑफ द इंडियन कॉन्स्टिट्यूशन. There are various types of fundamental rights. For example, right to equality. It is given in Article 14 to Article 18. Second is right to freedom. It is given in the Article 15, Article 15 to 18. And then there is the right against the exploitation. It is given in the Article 23 to 24. And there is the right about the freedom of religion. It is given in the Article 25 to 28. And there is another fundamental right. It is about the educational and cultural rights. It is given in the Article 29 and 30. And last, it's about the constitutional dignity. It is given in the Article 32. Fundamental rights are most important rights. These rights are basic rights which are important for the individual growth or development. These rights are important for the promotion of democracy in the country, and these rights are important for the establishment of equality, rule of law in the society. In Indian Constitution, we see that if there is violation of any of the right of any person or any individual, he or she can directly go to the Supreme Court or High Court. A Supreme Court and High Court has power to issue the writs for the enforcement of these rights. यानी कि जो सुप्रीम कोर्ट और हाई कोर्ट है उनके पास इन राइट्स को इन्फोर्स करने का एक पावर है. दे कैन इशू रिट्स. There are various types of writs like habeas corpus and mandamus, prohibition, quo warranto, etc. And here we must remember 2 important articles. First is Article 32 and Article 226. Article 32 deals with the power of Supreme Court to issue the writs, and then Article 226 it is about the power of High Court to issue the writs when there is violation of fundamental rights of any person. Now these rights are not unlimited, they are limited, and the state has power to put reasonable restriction on these rights. Even state has no powers to put arbitrary restriction on these rights. And these rights can be amended by parliament, they can be repealed by the parliament, and they can be suspended during the time of national emergency. जब भी नेशनल इमरजेंसी हो, राष्ट्रीय आपातकाल लगा हो, उस वक्त इनका सस्पेंशन भी हो जाता है. बट आर्टिकल 20 एंड 21 इनका जो है सस्पेंशन नहीं होता है नेशनल इमरजेंसी के दौरान. अब हम अगले फीचर पर आते हैं. इट इज डायरेक्टिव प्रिंसिपल्स ऑफ स्टेट पॉलिसी. दिस इज ऑल्सो मोस्ट इम्पोर्टेंट फीचर ऑफ इंडियन कॉन्स्टिट्यूशन. दिस principles are mentioned in the part 4 of the constitution. These principles are the basic direction or basic principle which state has to follow or apply during the time of lawmaking. यानी कि जब भी सरकार एक कानून का निर्माण करे तो वो इन प्रिंसिपल को वो मद्देनजर रख के वो कानून को बनाए. एंड दिस प्रिंसिपल एम्स टू एस्टैब्लिश वेलफेयर स्टेट and establish the economic and social democracy in the country. तो ये बहुत ही महत्वपूर्ण है. They can be classified in various categories, and these principles are not justiciable by the courts. ये जो है justiciable, non justiciable है. यानी कि if there is a violation of these principles, aggrieved person cannot go to the courts for their enforcement. Even court has no power for their enforcement in the country. अब अगले फीचर पर आते हैं. It is the fundamental duties. Originally, we know that there was no provision about the fundamental duties in our original constitution, but they were added in 1976 through the 42nd Amendment Act, and they are based on the recommendation of the Seventh Committee. And we know that these are also non-justiciable. They can't be enforced by the court through the writs. And there are various types of fundamental duties, like the respect of constitution and national anthem, national song, and it's also about the promotion of brotherhood in the society. There are various. There are 11 in a total. In total, there are 11. There are 11 duties in the Indian Constitution, and there is. Uh, they are also they are also important because we know that we have rights, we have fundamental rights. So with the rights, there are some duties which an individual or citizen has to has to perform in his country or in India. Now next feature is the integrated and independent judiciary. The most important feature here. Indian Constitution has provision about the integrated and independent judiciary. First, integrated judiciary की मैं बात करती हूँ. We have the Supreme Court on the top, and below this we have high courts at the state level, and there are district courts. There are below the district court there are subordinate courts. And there is a most important thing that all the laws, whether it is formed by central government or state government, can be enforced by all these courts. यानी कि जो सब कोर्ट है वो लॉ को वो लागू करवा सकती है. If we take the example of USA, there is a federal court which has power power regarding the federal laws, and it has no power for about the state laws. Even they can't enforce the state laws. अगर हम इसके जुडिशल के इंडिपेंडेंट की बात करें, there are various provisions in the constitution which ensure independence of judiciary. Like there is the security of tenure of the judges, and second there is the provision that no discussion about the conduct of judges can be done in the Lok Sabha and the state legislative assembly, and Supreme Court has power to punish any individual for the contempt of court. So these all provisions ensure the independence of the judiciary in India. Now last जो feature है जिसको डिस्कस करेंगे, it is the synthesis of parliamentary sovereignty and judicial supremacy. First of all, I would like to tell the meanings of these two concepts. First is the parliamentary sovereignty. This is British concept, and this judicial supremacy, it is the it's American concept. In India, there is the provision that parliament is not a sovereign. जिस तरह से ब्रिटेन में पार्लियामेंट सोवेन है, ठीक उस तरह से भारत में पार्लियामेंट सोवेन नहीं है. और जुडिशरी in same time the judiciary is not supreme in India like in America, but we have the synthesis, we have the mixture of these two concepts, because in India the parliament has power to make the laws, to enact the laws, and to amend the laws, but the judiciary has power to review these laws. And there is a concept, it is judicial review. Under this power, the court, the Supreme Court has Supreme Court has power to review the constitutional validity of the laws made by the legislature. यानी कि जो कॉन्स्टिट्यूशन का, यानी कि जो लॉस है जो कि विधायिका द्वारा बनाए जाते हैं, उनको वो रिव्यू कर सकता है इफ दे वायलेट द बेसिक प्रिंसिपल और द प्रोविजन ऑफ द कॉन्स्टिट्यूशन. सुप्रीम कोर्ट कैन डिक्लेयर देम नल एंड वॉइड. जो सुप्रीम कोर्ट है उनको वो निरस्त कर सकता है. तो भारत के अंदर एक जो चेक्स एंड बैलेंस वाला सिस्टम है वो काम करता है. भारत के अंदर ना तो पार्लियामेंट के पास पार्लियामेंट बहुत ज़्यादा एक सॉवरेनिटी है, और ना ही जो है जुडिशरी के पास जो है सुप्रीमेसी है. सो these are important features which we discussed in this lecture. And if we take its quick revision, first we discussed about the fundamental rights, various types of fundamental rights given under the various articles, and then we discussed the directive principles of state policy, and then we discussed the fundamental duties, and after it we discussed the integrated and independent judiciary, and at last we discussed the synthesis of parliamentary sovereignty and judicial supremacy. So these are most important features of the Indian Constitution. और इसी के साथ जो आज का जो लेक्चर है वो यहीं ख़त्म होता है. थैंक यू सो मच एंड नमस्कार.